Hello, this is Mickey Roberts. I'm an attorney here in Atlanta, Georgia. Today I wanted to talk to you about what I'm calling my case of the month for the month of September 2014. This case involves a car that was stopped and a search was performed on the car. Some drugs were found in the car and my client was charged with felony drug possession. Part of my practice includes not only DUI defense but any criminal case involving car, whether that is a vehicular homicide, a hit and run, or it can also involve cases where cars are stopped and later drugs are found in the car or on the person. In this particular case, my young lady was 20 years old. She was stopped after coming out of a hotel in Snellville, Georgia, which apparently has a reputation for known drug activity. She was stopped by a Snellville police officer for having a brake light out. The police officer did not smell any marijuana or alcohol, nor were there any physical symptoms of my client being under the influence of alcohol or drugs. In other words, there just simply was no evidence that would indicate there were drugs either on my client or in her car. Now what happened was the officer asked for her driver's license. He went back and made sure that her license was valid, and it was. And then the officer came back to the car and he asked my client, again who's 20 years old, if she would give her consent to searching the car, and she said no. Not only did she say no once, but she said no twice. The police officer then basically threatened that he was going to call a drug dog to the scene. She said fine. He eventually called a drug dog unit from another city. The basics of this case was that after a stop for an improper brake light, my client was detained on that scene for more than 28 minutes. Now eventually the drug dog came and they found a half a pill of methadone in my client's purse, which of course is a felony. There have been numerous Georgia cases over the past 2 years involving what are called prolonged stops. In other words, if a police officer stops you for a minor traffic violation and does not have probable cause to ask if he can search the vehicle, in other words, if he doesn't smell marijuana or alcohol, or perhaps he sees something in plain view. Georgia courts have held that the Fourth Amendment protects you from unreasonable searches and seizures. Now, in this particular case, we did have a motion, what's called a motion to suppress, which basically was to exclude the search on the basis that it violated my client's constitutional rights under the Fourth Amendment. The court ruled in our favor because, quite frankly, all of the cases in the last couple of years that have come out of the Georgia Court of Appeals, the trial courts in those situations had actually upheld the legality of the search, and the trial courts were reversed. In other words, the Court of Appeals told the trial courts, you are wrong in this decision. So in our case, the trial court granted our motion to suppress. All of the evidence was thrown out. The district attorney's office could not prosecute my client. Now again, this is a situation where a car was stopped for a minor traffic violation and there was no evidence of potential drug use. Georgia courts have held that if there is no probable cause to ask for search, then when the cop does ask for a search, that violates your Fourth Amendment rights. My advice, of course, is to never, ever give your consent to the search of the car. If the police officer has probable cause, that's fine. If a drug dog is already there and hits on something, that's fine, but you should never consent to a search of your car. Exercise your Fourth Amendment rights. Thank you.